Hi students, this is Professor Faith and I'm recording this lecture for my business law students. This lecture comes in Unit 3 of the course materials with regards to the UCC product liability and in particular warranties under the UCC. So I just wanted to introduce this material. You've had a chance to read about some of these interrelated causes of action. And I wanted to kind of point out again some important differences under the UCC for contract law compared to the common law. So, as a matter of definitions, warranties in general are promises of some sort by a seller of a good that the good will work in a certain way to a buyer. And so, it's really a set of promises to buyers from sellers under the UCC. The idea of warranties exists in the common law as well, but really I think what's important here is that you're talking about express warranties, warranties that are probably in the written contract under the common law or potentially are discussed in an oral contract under the common law. And so that's the limit of it. They're part of the contract in the sense that they are promises, and they give you some kind of a relief if the goods or the whatever is sold doesn't meet what the warranties say. But the common law doesn't have implied warranties. These are specific to the UCC for the sale of goods. So that's an important difference. Warranties in general are kind of the same thing, whether it's common law or UCC, but the warranties that we're talking about under the UCC are a little bit more narrowly or specifically defined, and some are implied in all sales transactions unless effectively disclaimed, which is not the case under the common law. There's no such sort of general warranty across all contracts under the common law. As you can imagine then, this topic, there are several different kinds of warranties that we'll be talking about. As I mentioned in the slide says, express warranties are those that are written into the written sales agreement or are stated by the seller about factual issues about the performance of the goods. And generally these are made at the time of the sale. I don't think you'd get a warranty long after you'd entered into a contract for sale. I think it would be around the time of the sale, typically, that these would be discussed. And they often are a part of the reason why a buyer buys a good, are the express warranties that are made by the seller. For example, if you ever go over to a car dealership and you're looking to buy a used car, or a new car for that matter, there's a sticker that's supposed to be attached to the side of the car, and it describes the features and functionality, but it also describes the warranty. And you know you can buy a used car with no warranty at all, or you can buy one with a 30-day general warranty, or you might buy one with a longer warranty that's more limited in terms of what it covers. There's a variety of different kinds of express warranties that might be offered to you as a part of the sales transaction. But that's kind of what I picture in my mind is in terms of what an express warranty in general would look like, is some kind of written document or an oral statement about factually what will work in the goods. Implied warranties are by statute, and there are several of these that are established by the UCC in terms of implied warranties. So regardless of whether you talk about them, these implied warranties, unless they are disclaimed, appear in all UCC sales contracts. And so there are several types that we'll talk about that serve different purposes. Finally, there's the concept of disclaimer. So I can disclaim a warranty by making a sale as is or with all faults. By expressly stating that this is a sale without any warranties, that means there's no express warranties and no implied warranties under the UCC in most circumstances with regards to a disclaimer of that sort. So with regards to express warranties, the obvious example is I warrant that this good will work for 90 days as described. or I warrant that this good will work for your lifetime, as described in whatever documents I give you or however the salesperson describes it. They're statements of fact about the goods, but not statements of opinion or puffery. And so the textbook talks a little bit about the difference between them. When I offer you an opinion about how this is probably the best sliced bread ever, that's a little bit different than saying that the bread is edible or the bread is going to work for the recipe that you need it for to make stuffing. Those are factual statements, not opinion or puffery. So it has to be a factual statement about how the goods are supposed to work or how long they're supposed to work or so on. Interestingly, if you go to a store and there's a model set up of the good that you're going to use, and you can touch the model acts as an express warranty as well as part of the sales process. So it doesn't have to necessarily be a written document or manual that you get. It could possibly be a model set up in the store. And if you can, look at the model, work with the model, then the item you should buy should work the same as the model. It's treated as an express warranty as well. Now, the implied warranties come in several different types. And again, it's possible that you have no express warranties at all. I just don't say anything about whether the goods are going to work a certain way or not. And so there's no express warranties. But you could still have implied warranties in the transaction with the seller. The two that are mentioned on this slide, one is merchantability, the other is fitness for a particular purpose. So those are two implied in sales transactions under the UCC. Merchantability is you buy a good from a merchant, it should work for its ordinary intended purpose, whatever that is. So the UCC treats this merchantability warranty only as to merchants. We talked about that previously in the course. Non-merchants can't offer a warranty of merchantability. It's not implied in that transaction. It requires a merchant, and then it's reasonably fit for its intended ordinary purpose. So if you go to the store and you buy some milk and you get it home, and it turns out that it's spoiled for some reason. It's not fit for its ordinary intended purpose of consumption. It gives you a right to go back to the store and get your $3 or $4 back, or get a replacement from the store. That's really that implied warranty in that sale. No one had to talk about it at the checkout counter. It's just a part of the deal as a part of the UCC. Fitness for a particular purpose is when I go to a merchant or a seller, not necessarily a merchant, but a seller that has expertise in the area, which probably is a merchant, keep that in mind, but it doesn't, I don't think that fitness for a particular purpose requires a merchant. But it does require someone with expertise that you communicate to them what it is you're trying to do, and you rely on their expertise to make a decision about what to buy. It has those two parts to it. If you go to just somebody that doesn't know anything about whatever you're trying to do, and you say, I want to do this, and they say, well, I don't know, but maybe you should try this product. That's not a fitness for a particular purpose situation. You have to go to somebody who's an expert in the area that's a seller to be able to get a fitness for a particular purpose. And then you got to tell them what you're trying to do so that they can tell you what to buy to achieve that result. So you have to have more of an interaction with somebody with expertise at a retailer for that to work out. But it's possible that you can have one or both of these warranties in the same transaction. Just depending on what happens determines whether these implied warranties would apply. Now, the other implication or implied warranty has to do with title, non-infringement, and then potentially industry trade practices. So kind of bundled together under title warranties, but it's three different things really. One is that the seller has good title to the goods they're selling to you and that they're free of any liens. That is that if they owe money to anybody else, that it's not your problem as the buyer, it's their problem to take care of the liens or obligations to other persons that perhaps financed the purchase of the inventory, for example, or some other kind of general security interest. That should not affect you, and if it does, then you have a right to sue the seller. For example, if you were going to buy a car from me and I offered you it for sale. Implied in that transaction is that I have good title. And if not, I should get good title to transfer it to you. And so sometimes if you go to a dealership, you notice that the title documents are not necessarily yet in the dealer's name, but they have a signed title from somebody else that sold it to them. And so that gives them the right to get good title and transfer it to you. But if it's me selling it to you and I don't even have any title, or it's a stolen car, for example, I can't give you good title. It violates the title warranty under the UCC that's implied in that transaction. It'd be the same as if I sold you a car that I had borrowed money to buy, and then I didn't satisfy the loan with the sale proceeds. And so the lender gets mad and they have a right of repossession. They come and repossess the car, which you now have in your possession you thought you bought from me. That's also a implied breach of title warranty to do that. The other sort of related to this is I can't sell goods to you that violate someone's trademark, copyright, or patent rights. I'm making a warranty that I have good, non-infringing goods for you, and that they don't violate the intellectual property rights of other people. And then finally, there are certain trade practices in certain industries where you're entitled to something as a part of the sale because it's the customary way that business is done in that particular industry. I have here as pedigree papers, for example. If you buy a purebred animal, purebred dog, you have a right to papers that document the parents of the puppy that you purchased, so that if you wish to register your puppy, you can say, well, my puppy is a purebred dog because its parents were both purebred, and here's the documentation of that that connects them together. So you have a right to that in certain industries, that document, whatever that might be. If you don't get it, you have a warranty action under the UCC. Now, as I mentioned, you can sell goods subject to no warranties, and you can disclaim all warranties. For example, it's very common if you go to an auction. Absolute auctions generally are as-is sales. And absolute auctions, the hope of buyers is that they get it cheaper compared to what its retail price is. But with that comes the risk that it may not work. And often the auctioneer isn't going to test in advance. And so there is no warranty of any sort. They're often sold that way. Cars sold at auction, if you ever watch Storage Wars, the auctioneer that's selling those storage unit contents is not warranting any of it's any good or it has any value at all. It's just based on your own visual inspection before you bid. But there's no warranties of any sort as to the goods. So it's possible to do that. I'd say that probably not as common as a limited warranty or some other kind of specific express warranty, which is discussed a little bit more in detail in the textbook. But by federal law, there's actually a bunch of rules about when you have a general or limited warranty, what it has to say, that there has to be some consistency in what those warranties mean across industries. And there's a regulation actually that's talked about in the textbook that gives you all the things that are supposed to be in it, limited warranty or general warranty, what that's supposed to cover. And so there's a compliance aspect to when you issue a warranty under the statute to fit within what the regulations require. Otherwise, you might have an invalid warranty that you're offering as a seller, and I think that's worse for you than just simply complying with the regulation. But this is very common in consumer products that you see this, that goods over $10, you go to the Apple store and you buy an Apple product, or you go to the laptop store and you buy a laptop, the booklet that you get with it as part of the sale generally describes what the warranty is. And, the warranties on that electronics device are not much different than warranties from other makers of other devices or other goods. That consistency is not accidental. It's actually because there's this FTC regulation that requires that result. And what's interesting about the regulation is it also forbids certain kinds of warranties. For example, ones that essentially disclaim all implied warranties, and the express warranty isn't much of a warranty at all. That's a phantom warranty. And the regulation said you can't do that as a seller, that, if I'd be worse off with the express warranty than without it, then you probably can't have that kind of express warranty. While consequential damages could probably be limited by all warranty statements or disclaimers, the reality is you probably, in some states, can't disclaim any implied warranties when you give an express warranty, at least in consumer transactions, and in some cases in also commercial, though there's less overall protection for commercial activity in terms of this stuff. But there's a bunch of limitations in terms of the content and also on what you may disclaim when you issue such a warranty overall. And so that's another potential cause of action. If you get injured by a product, it might be that you have a direct action on contract with the seller. You might have a warranty action provided under the UCC or implied in the transaction by the UCC. And then it's also possible that there's a negligence aspect to the injury or a product liability claim. And so you might bring all of those actions together. Again, they give you different remedies against potentially different people involved in the sales transaction. But you might need all of them, which is, unfortunately, it's the cumbersomeness of getting a remedy when you're an injured plaintiff. But you get these different tools in your tool belt. And the reason why it's this complicated is really because these laws have grown up over time kind of in parallel. The common law of product liability as a tort is separate from the UCC statute as to warranties. They're really from two different sources, those things. And then, of course, our concepts of contracts come from a different body of common law and the limitations on contract actions there. Whereas negligence is its own category of action, again, under a different set of common law cases. So you end up with 4 different kinds of remedies, 4 different kinds of actions when you're dealing with products that injure somebody. And you'd have to really think it through in the big world about how these all work, because they apply to different parts, different aspects, give you different remedies potentially, depending on what your injury is.